Thanks everybody for coming. My name's Tyler Giannini, and I co-direct the Human Rights Clinic with Susan Farbstein, who's to my right, and I want to welcome everybody on behalf of the American Constitutional Society, the Human Rights Program, and the Human Rights Journal at Harvard Law School. This is part of a larger symposium on the future of business and human rights, and this is the kickoff keynote. We've had a little bit of a change. Paul Hoffman's going to be joining us by Skype because of difficulties with travel. So we're going to get him started. And so that's one logistical change. The other thing that is worth saying is that this is being videotaped. So any questions or comments that you have that you want to say at the end will be taped. And we just want to make you aware of that. Brief introductions. The way we're going to set this up is that Paul Hoffman is going to join us by Skype. He is a renowned human rights litigator, and of most relevance today is that he has argued the two prominent Alien Tort Statute cases before the Supreme Court, both Sosa v. Alvarez-Macian and Kiobel versus Royal Dutch Petroleum. So he's going to be speaking about that and the last year of litigation under the Alien Tort Statute. Because he's not here, we're going to then, after he speaks, have a moderated discussion that Professor Feldman is going to be leading with three of us here who are also Alien Tort Statute litigators. Professor Feldman doesn't need any introduction, but he is the Bemis Professor of International Law here and a renowned constitutional scholar and has followed the Alien Tort Statute closely. So we're looking forward to him asking some tough questions about the statute and the litigation over the last year. To his left is Marco Simons, who's the legal director of Earth Rights International, has litigated numerous corporate cases under the Alien Tort Statute, including Bowoto versus Chevron and Shell versus Wewe. To his left is the co-director of the International Human Rights Clinic, Susan Farbstein. She has also litigated numerous cases and is co-counsel on the apartheid litigation. She's also litigated the Shell v. Wewe. I've also litigated cases before the corporate cases, including Doe v. Unocal. So I'm going to sit down so we can get started and get Paul on the phone. We're going to have about an hour.
Okay. Thanks. And I'm sorry I can't be there in person, and I'm sorry I can't actually see you, but let me get started. The big issue, there you go, I can see some of you now. Hello, Susan. Hi, Marco. How's the baby, Susan? The issue that I'm going to talk about is sort of what's happened since Kiobel, and since it's 15 minutes, probably just about extraterritoriality, although there are other things that one could talk about with respect to the Alien Tort Statute after Kiobel. And so the big question is, did Kiobel wipe out the Alien Tort Statute? And if you talk to any defense lawyer, they would tell you that it did, because virtually all ATS cases prior to Kiobel from Philar have been extraterritorial, in the sense that the human rights violations took place outside the United States. And so if the defense bar is right, I have wasted the last 34 years of my life in this area of litigation. But I don't think that they are right, and we won't really know that until Justice Kennedy reveals his position on extraterritoriality. And I think we may know fairly soon, because there are a number of cases coming up through the circuits, which I'll talk about in a minute. But let me start by saying that I don't think that the defense bar is right about what Kiobel actually says. That may or may not matter ultimately, but if you take a close look at the opinions, what the defense bar has focused on, and what some courts have focused on, is that the first three sections of Chief Justice Roberts' opinion seem to suggest that the presumption against extraterritoriality wipes out all ATS cases where the events took place outside the United States. And Justice Kennedy joined in that, so there are 5 justices that signed on to that opinion. The confusion, it seems to me, comes from 2 different places. One is that there's a Section 4 to the Kiobel opinion that says that if a claim touches and concerns the United States with sufficient force, that maybe the presumption is overcome. And it also says that clearly a claim like the one in Kiobel, where there's mere corporate presence in the United States, and where it's really a foreign cube case. And what we mean by that is that the plaintiffs were non-resident aliens when the events happened, that the defendants are alien corporations, and all the events took place in another country. In Kiobel, that was all in Nigeria. And so in Section 4, by referring to mere corporate presence, it appears that that's talking about the fact that the case was a foreign cube case. And most of the briefing in Kiobel at the Supreme Court level on extraterritoriality focused on the fact that it was a foreign cube case, as opposed to a case involving a U.S. corporation or where there was some U.S. contact of some sort. And Kennedy, in particular, in the first Kiobel argument, wanted to know why this case was in the United States, because there was no connection to the United States. So it could be that connection is more important to Justice Kennedy than geography. But we don't know that. And then, and also in the first 3 sections, the presumption as defined in the Kiobel majority opinion by Chief Justice Roberts is not the usual presumption against extraterritoriality. Usually, either the presumption applies or it doesn't. Either the law is extraterritorial or it isn't. And the presumption defined by the Kiobel opinion is not one that seems to be either 100% extraterritorial or not. And one of the reasons that that's confusing is that the court should have found that because the ATS was acknowledged to apply to piracy, that the presumption against extraterritoriality didn't apply. So they had to find some answer to piracy. They really didn't find an answer to piracy other than it didn't matter to the presumption that they were creating. In addition to that, there's a very famous historical example that Tyler and Susan can talk about at much greater length than I, involving an attack on Sierra Leone in 1794, which was the subject of an Attorney General opinion in 1795, where the Attorney General of the United States said that the Alien Tort Statute did apply to an attack on the territory of a foreign sovereign, in this case a British colony in Sierra Leone. And what Chief Justice Roberts said is that the Bradford opinion was a little unclear, but in any event, it had to do with an attack that involved U.S. citizens. Well, if U.S. citizenship matters in the context of presumption against extraterritoriality, we would have to see what happens when cases come up to the court that involve the actions of U.S. citizens. And the concurrences, in particular Kennedy's and Alito's, both acknowledge that the majority opinion is a narrow opinion. And it's hard to imagine that it's a narrow opinion if it actually wipes out an entire body of litigation and all the cases that are pending before the courts around the country. So it's not clear. And it's only Alito and Thomas that take the narrowest view that all of the events that give rise to the cause of action under the Alien Tort Statute have to take place within the territory of the United States. So there are only 2 justices for that position. So what does all of this mean? What all of it means is that it's fairly clear that Kiobel is a negative decision towards Alien Tort Statute plaintiffs. I think we'd have to acknowledge that. But it leaves a lot of questions unanswered, it seems to me, and I guess the proof of that will be how the courts deal with Kiobel below. And let me just give you a quick tour of what's happened on that. In the Second Circuit, the circuit that gave us Kiobel, there are two primary decisions at the circuit level. Both of them also written by Justice Cabranes, who apparently has been designated by the Second Circuit to write all ATS opinions now and forever. And Ballantulo is the cases involving apartheid in South Africa. And at least two of the defendants in Ballantulo were U.S. citizen defendants, Ford and IBM. And Justice Cabranes basically takes a fairly hardline view on Kiobel, that Kiobel should be equated to the Morrison case, and it is the presumption against extraterritoriality, and it applies to wipe out the ATS claims in the apartheid cases because there's really no connection or action on U.S. territory. Another case, Chowdhury, involves actions that all took place in Bangladesh between Bangladeshis, and Judge Cabranes had no difficulty applying Ballantulo to Chowdhury to wipe that out. So Ballantulo, if you put it together with Chowdhury, suggests that in the Second Circuit now, the fact that a defendant is a U.S. citizen does not matter in terms of overcoming the presumption. But it leaves open the possibility that if there's significant or even some U.S. conduct, that the presumption might be overcome, but does not really get into what that might be. In the D.C. Circuit, the Doe versus Exxon, which had found that the presumption against extraterritoriality did not apply to a case involving human rights violations in Indonesia, was vacated after Kiobel for further consideration in light of the opinion that's been briefed at the district court level, and there's been no decision there. So there's nothing at the DC Circuit. In the Fourth Circuit, there's a case called Alzawahri, which has to do with the actions of U.S. contractors in Iraq. There, the district court applied very much an analysis very much like Ballantulo to dismiss the case. That case was argued in the Fourth Circuit last month, and it's not clear what the court will do there. And that's a big test of the question about whether the fact that there's a U.S. citizen involved matters. And I still think that that's an issue that may get different consideration at the Supreme Court. And one of the reasons for that, just to go back into Kiobel and to the ATS, it's acknowledged that one of the incidents that took place, that gave rise to the Alien Tort Statute, was an incident called the Marbois incident, where a French ambassador was attacked in Pennsylvania by another Frenchman, actually. But it's hard to imagine that if a French ambassador had been attacked by a U.S. citizen outside the United States, and that U.S. citizen came back to the United States, that the French ambassador would not have had an action under the Alien Tort Statute. And it seems to me that that's going to be a difficult, well, maybe it won't be a difficult issue for the court to get around, but it should be a difficult issue for the court to get around. In the 11th Circuit, there's another case involving substantial U.S. action, which is Doe versus Chiquita, which I'm sure Margo would be happy to talk about in more detail. But we're arguing that case next Thursday in front of the 11th Circuit, and the Kiobel issues are front and center in that argument. They have been raised only on appeal, which is the case in many of these cases, because a lot of the district court cases were decided before Kiobel was decided. And then finally, in the 9th Circuit, my home circuit, in Doe versus Nestle, the panel rejected the defense argument that Ballantulo should apply, and that a case involving only conduct, at least on the face of the complaints, in the Ivory Coast should not be dismissed, and instead the court gave us leave to amend so that there could be further consideration in the district court. But I would have to say that the panel did not give us much analysis about what it thought about the circumstances in which the presumption against extraterritoriality would be overcome. And then in a case called Mujica versus Occidental Petroleum, which was argued March 5th, again, there is little U.S. conduct on the face of it, and the court is dealing with the conduct of U.S. corporations in connection with a war crime, the bombing of a village in rural Colombia. And it's not clear how the panel will deal with that. And I would think, because it's always happened in the Ninth Circuit, that as soon as the panel decides, it'll go en banc, since it did in Doe versus Unical, it did in Rio Tinto. There's a big division of opinion in the Ninth Circuit about the scope of the Alien Tort Statute, and I would expect that they would want an en banc panel to decide that. So we're waiting on that. So the bottom line on this is that the early decisions are not, by and large, less favorable than we hoped. There are some exceptions to that. There's a case in Massachusetts, sexual minorities, involving the actions of a U.S. evangelist that led to persecution of the gay and lesbian community in Uganda, where the court found that the presumption didn't apply. There's another Philartiga type case in Ohio, Ahmed, where the court found the same. And I actually think that Philartiga cases will be treated differently from corporate cases, ultimately. In this, how they will reconcile that, I don't know, but I think they will do that. And so everything is up in the air in the ATS world until the circuits come forward with this next round of opinions and the Supreme Court takes one of them to decide what touch and concern means, what mere corporate presence means, what are the circumstances in which the presumption against extraterritoriality can be overcome, and all the arguments that are possible to make have been made in all of these different cases, and so the courts have a smorgasbord to choose from. We'll see what they do. Apart from, and maybe I should just stop, but let me say a couple of words about just the other issues that are lurking there. There's still an issue about whether corporations can be sued under the Alien Tort Statute. That was the case that the issue that the Supreme Court originally took Kiobel on. And the Second Circuit is now trying to figure out whether the original Circuit Court Kiobel opinion actually still applies in the Second Circuit. In other circuits, corporations can be sued. In the 11th Circuit, the 7th Circuit, the 9th Circuit after Doe versus Nestle. And I suspect that's what will happen. What the Supreme Court would do with it if it got it again, I have no idea. And then the other issue is just the big issue that actually was the big issue prior to Kiobel is aiding and abetting liability and what the standards are for it. I think it's pretty clear in almost every circuit that it exists. The trend is that it's international law that applies to the standard for aiding and abetting, and that the mens rea standard is purpose, which has not been the plaintiff's favored standard. Although in the 11th Circuit, I think the standard is still knowledge. But it'll be interesting to see how the courts deal with those issues if they get a chance to, after dealing with the presumption against extraterritoriality. But I should stop there. I've already spoken too long, probably.
So let's just start with a question of background strategy. And I would put the question this way, and I should just say there's a question of balance here in that everyone speaking and in the room is not only a person committed to the idea that Kiobel is wrong, but is a career-long, distinguished litigator arguing these things. At one stage, it seemed possible that my co-author Kathleen Sullivan was going to be here. She argued the other case. And I'm, to some degree, a stand-in for Kathleen. But I'm not going to make Kathleen's arguments, which I'm not sure I agree with, but I am going to try to ask questions in a tough way so that we get some sense of the full picture. So let me start with what I think is the hardest, meanest question, and it's this. After the wafer-thin victory, if you can call it a victory, of Alvarez McChain. Did, collectively speaking, the human rights litigators go too far by pushing for corporate liability? In other words, there's a credible case to be made as a strategic matter that after Alvarez, the court wasn't actually going to end Filartiga-type human rights litigation, though it came extremely close to doing so. But it wasn't going to reach out and try and find an opportunity to more or less reverse itself. By pushing corporate liability, an issue was created that was cert-worthy. The court then heard it. It heard oral argument on the issue of corporate liability. And in that course of that process, Professor Goldsmith here at Harvard wrote a completely original new brief making the argument from extraterritorial application that was written to appeal to Justice Kennedy, and this is not a secret, it was a for-profit brief that Jack wrote. Jack was a former Kennedy clerk, understands Kennedy more than anyone else. So Jack produced this brief, which I think it's probable he would not have produced on a pro bono basis. Kennedy went the other way, and boom, we have a symposium on the future, i.e. the potential death of this whole area of litigation. So question one, meant to be a hard question, did you push too hard and have it explode in your face?
Who wants to go first?
I can give some thoughts on that, but first I'll give my standard video recording disclaimer, which is that the thoughts I'm about to give are my own and not on behalf of my clients. As Paul knows, occasionally opposing counsel have tried to throw remarks such as these back in our faces for nefarious purposes. And in this case, some of the thoughts I give might not be entirely my own, because I might play devil's advocate a bit. But did we push too far, too fast? I think in retrospect, yes, because we suffered a pretty serious setback in the Kiobel case. Whether that was predictable in some ways, whether it was a strategic error ex ante, I think is a more challenging question. And I look at it from the perspective of what the goal of this field of litigation is. And the Filartiga type cases, for those of you who haven't been immersed in this field for years, that basically that's just the shorthand for an individual human rights abuser typically found in the United States, either visiting or having relocated here after typically regime change in their home country, gets sued by a victim. And what results from those cases is typically a decision, in the early cases almost all default judgments, a decision that recognizes that the abuses were occurred and validates the victim's experience and establishes a precedent in international human rights law, but almost never results in any substantial remedy to the victims. There are a couple of exceptions, but that's the general model of those cases. And from my perspective, the reason to push on the corporate cases is to make the jump from declaring the wrongness of this conduct and establishing the international precedents to actually having both a deterrent and compensatory function involving wrongdoing on a large scale, which is much more possible when you sue actors who are repeat players, who are deterrable, and who have money. And so the way I look at the question is not whether we pushed too far, too fast in suing corporations, but essentially what good is the Filartiga line of cases if we're not pushing farther than that? It is good for some things, but I think that the benefits that have resulted from the corporate litigation have been widely felt in the business community. and have contributed to developments at the UN on business and human rights that we'll talk about later in the symposium. But that in terms of actually changing behavior, I think the corporate cases have had a much larger influence than the individual defendant Filartiga-style cases, because individuals in these contexts typically are not nearly as deterrable as corporate actors, and they can't really remedy the harms most of the time when they're sued. But I do think there were some interesting developments in terms of how we got to Kiobel, which is that Kiobel is one of the very few foreign cubed corporate cases. That is actually the exception rather than the rule in corporate cases. The vast majority of corporate cases have been against U.S. corporations. And I think Kiobel only happened due partly to a historical accident of which issues were decided first, because if the Supreme Court had decided a case that it decided this term, which is Daimler Chrysler v. Baumann, if they had decided that case before Kiobel, Kiobel never would have gotten to the Supreme Court, because what the Supreme Court decided in the Daimler Chrysler case was that a foreign corporation like Daimler Chrysler essentially was not subject to general jurisdiction in the United States for anything, human rights abuses, general torts, anything. And it seems fairly likely that under that personal jurisdiction decision, that you wouldn't have been able to sue Shell in the United States to begin with. And so Kiobel, just to wrap up, so Kiobel may reflect an uncomfortable, the Supreme Court's discomfort in cases that have nothing to do with the United States on the level of a foreign corporation being sued here, that really found its true home in the Daimler v. Baumann decision. And rather than an ultimate discomfort with suing corporations for human rights abuses. That remains to be seen, but.
So you should continue to talk about this, but let me just sharpen a little bit. I mean, that was a fascinating answer, and there are three themes there that I just want to open up. So the first theme is that the move to sue corporate defendants was a move from symbolism to effect. So I want to make that an important theme, and I want to hear what you guys think about this. The argument, if I understood you correctly, and I think this is also correct, is more or less that the old form, the Filartiga-style litigation, was really about the symbolism and drawing global attention to human rights violations. And seen in that way, litigation was an important tool in the toolkit of human rights activists, functioning as some other of those tools do, to draw attention to human rights abuses rather than to remedy them immediately. The drawing attention being the first stage towards eventual remediation or future prevention. The shift to corporate clients then is designed to effectuate. And the first question to ask about that is, isn't that perhaps exactly why the Supreme Court wanted to draw the line? That it could tolerate the symbolism, but it was not prepared to tolerate its effects. A second question that arises from this, and I'll just turn it back to you guys, is the changed political economy of going after the corporate actors. So as many of you know, in politics generally, and I'm treating here litigation as a tool of politics in this context, but in politics generally, the best person to be is someone with a concentrated interest on your side and a diffuse interest on the other side, right? Because a diffuse interest that's sort of like, I don't know, the Cuba lobby or the Israel lobby. The great advantages of those lobbies is not so much their money and strength, though they have those things, as that they have concentrated interests behind them, and on the other side are largely, at least in the American context, diffuse interests. And a lot of their strength is attributable to those features. When you are going against individual human rights violators, you're concentrated because you care about human rights, and the other side is diffuse, because there's no large constituency of individuals out there in the world who defend against human rights violations. When you bring the corporations into it, you radically change the political economy. Suddenly you have a concentrated corporate interest that wants to defend itself, transnational, multinational corporations, not just concentrated, but big and rich, and able to convince the courts, both practically and de facto, that there's a real interest in play. So the second question is about whether you agree that you kind of, by going after the corporate actors, you activated a far more organized, effective, and concentrated opponent than you otherwise would ever have encountered. And then I guess the third question is this question of that Marco raised of what really motivated the court here. You know, what really got to the justices? And I guess I just want to raise the question of how much does that matter? You know, I mean, guessing what Justice Kennedy is going to do is also known as my job, namely studying contemporary constitutional law. So now, welcome to the club. You guys also have to spend your time guessing what Justice Kennedy will do. But that complicated question might be a little different from what, quote unquote, was really bothering. You're not really asking what was really bothering the other justices, right? You're only really asking what was, quote unquote, really bothering Justice Kennedy, and he's now on the record as having signed Kiobel, though with this very don't think that my vote is in the bag, please look at me, form of concurrence. So three issues. Broadly speaking, the three issues are symbolism versus effect, changed political economy, and guessing what's in Justice Kennedy's mind.
So we really have too much to talk about, but maybe if I can just throw a couple of thoughts out here, both in response to what Marco said and then in response to these questions. So one piece of the puzzle that Marco sort of picked up on, which I think is correct and worth emphasizing, is that no matter what happens with the future of the corporate ATS cases, and as Paul I think correctly said, there's a lot of fight still to be had, is that they are very much the scaffolding on which the corporate social responsibility, corporate accountability movement has been built. So you're right that we might not be here talking about the future of the ATS, but I'm not sure we would necessarily be here talking about business and human rights more broadly if we didn't have the corporate cases. So in terms of the impetus for the GPs and all of these other pieces of the puzzle, the other ways that corporations have had to change their behavior and think about where the lines are going to be drawn, I think the cases have been really important for that, and that matters. And I think the cases have also been really important in terms of activating accountability movements and cases in other jurisdictions. So we can talk more about, you know, what the future looks like outside of the United States, but that's an important piece of the puzzle. I think in terms of the question about did we push too far too quickly, that's also sometimes a question that we're asked with respect to Wewe in particular, and I think it's worth reminding everyone, as you said, we are litigators, that sometimes you just have an obligation to your clients, that if your clients feel the need and want to push a case forward, even if it might not be the perfect, from a strategic perspective, case to bring to the court, there's an obligation to do so. And I think particularly in the Kiobel-Wewe pairing, where Wewe, which is a case that comes out of the same incident, the same set of facts, successfully settles in 2009, and there's a similarly situated group of plaintiffs that's looking at having nothing left. There was a good reason to continue to push the case forward. And then just to say something quickly about sort of what...
Can you say just a word about the background to that? So the people know about the Ken Saro-Wewe case, but what was the relationship between the petitioners in Kiobel, and they were not included in the Wewe settlement, but can you just say a word more about that?
Yeah, I actually think maybe Marco should be the one to talk
Right,
about
we'll
that, because he was involved longer than I was in the Wewe case.
I don't know the procedural details.
And it's messy, but I'm going to leave that for Marco. Yes. I think the third piece that I wanted to say had to do with your question about did we sort of I don't know exactly what the word was, but I think we did activate a stronger response when we switched from what we often call the dictatorship phase of litigation to the corporate phase, and I think part of that has to do with the amount of money that was suddenly at stake, that you see large corporate firms now have an interest in a way that they didn't when you have a single individual who, even if you get a judgment, there's not necessarily going to be money at the end. So let me leave it at that and let Tyler jump in.
I agree with things said so far, so maybe just to amplify a couple things or take it in a slightly different direction. I think on that last point, Susan's point about activating, I think the amount of effort that has gone into the corporate phase since the mid-90s, and I think it really is an activation that occurs then, not SOSA, which I think is important because I think the predictability of Morrison coming, Goodyear, Daimler coming in the mid-90s is a much harder prediction. So I think that's part of it, is by the time SOSA comes down, you are predicting in a different context. You already have cases that are active, so the ability to not do things is already hard because of your clients, and that's part of the equation, I think. But I think the activation, of course we knew as we brought the initial cases that there would be a different response. And so I don't think it's so much that you didn't know there would be activation of different resource levels, but I think the intensity of it and the sustained efforts led to a different discussion than during the dictator phase, which I think is not all bad. I think some of the things that actually the byproducts of this fierce litigation are bad cases like this, like Kiobel and an outcome, but it's also to get down to where do you draw the line, which is a very important discussion, not just for human rights lawyers, but for businesses and industry. The progressive industry wants to know where to draw the line. And by litigating fiercely, we get that. I think the byproduct also of having defense firms involved is that they're also advising before projects get started. And so this is part of this. I think that the effect is not just the case, but it's these other pieces, the building of an infrastructure around business and human rights, the internal discussions that are happening in large law firms that lead to different advice scenarios for companies. Those are all good things. And I think that's also that I wouldn't say there was no effect, even though there was no compensation during the dictator phase. People found it harder to come to the United States. So that's a broadening out what is seen as the remedy, I think, is part of the equation here too.
Can I ask a question that turns a little bit to the particular fascinating feature of the relationship between appellate courts and the Supreme Court in this particular area of litigation? So for those of you who are interested in social movement lawyering, often what you see is that progressive litigators have the goal of getting to the Supreme Court. Right? That's sort of the picture of the LDF.
Or avoiding.
Here, or the picture in the gay marriage cases. Right? It's about timing your move to the Supreme Court so that you get your ultimate victory in the Supreme Court. So this area of litigation is, I don't want to say uniquely, but it'd be interesting to think if there are other examples, devoted to the opposite proposition. So between Filartiga, which is basically the Brown against Board of Education of this movement, and Sosa is just about 20 years. And those are the glory days of this litigation movement in which the Supreme Court is just by denial of cert letting things run their course. That Sosa is this, in my view, incredibly close shave, where if you read the opinion without the syllabus at the front of it, you think it's going to put an end to the Filartiga style of litigation, and then in the last page, almost like a page, like a novel, it suddenly flips and something is preserved. And then obviously this trip to the Supreme Court went even less well. So I guess my question is, going forward, as we were hearing from Paul, this very detailed account of all the cases in the different circuits, what strategies will you adopt collectively to try to keep these cases out of the Supreme Court, to try to make them bad vehicles, to try to make them fact-bound? Because but probably, if you come back to the Supreme Court too soon, Justice Kennedy is going to be shamed into going by Justice Roberts into extending his position. This is my personal opinion, you really don't want to pressure him too soon on this. And he himself clearly doesn't want to deal with it, having written this concurrence. So what strategies do you fulfill to avoid cert grants? What's your sort of way of going about that, assuming that is your goal?
Should we ask Paul?
We're looking for secrets of the trade here.
I don't know, do you want to ask Paul?
Can we get Paul?
I think that it's one of the things that Susan said before, which is the problem, and that is we have clients in all these cases that have been brought for some of them have been going on for 10 or more years. And so it's a little bit hard to just decide as a movement which cases should go up. My experience, and certainly the experience in Kiobel was, I don't think any of us wanted to go up to the Supreme Court in Kiobel. But as Susan said, the clients had an interest, and we felt that their interest trumped the interests of the movement. And I'm afraid that that's probably the case in all of these other cases. We'll use the traditional, means of opposing cert. One strategy that I don't think would be a really good one would be to lose all of them. and just not just not petition. I think inevitably one of these cases is going to go up. But I agree with you. I think going up too quickly is not a good idea. And one would hope that the case that will go up first would be the one that has the most connection to the United States. And I think that it might be possible to work on the timing of that by different kinds of things that we could do. That would be the best case, it seems to me, a case where there's a lot of U.S. contact, and it really looks completely different factually from Kiobel, from a foreign cube case. I don't know what else we really can do. One just quick point about Sosa. Sosa, I guess you could look at it as wafer thin from the outside, but when we looked at it, we saw 6 justices that basically endorsed Florida type cases and rejected some very extreme positions, including an argument that the presumption against extraterritoriality applied. And so, I don't know that we could have predicted that Alito would replace O'Connor. And I think if you look at Kiobel, if O'Connor was there instead of Alito, we probably win, I think. So it's not clear. And when you have cases that start so long before, it's very hard to predict the changes in the executive branch, because when Democrats are in, they support our cases usually, and when Republicans are in, they go against them. But how do you predict those things? So we've been faced with this quandary that we've been bringing the cases based on human rights principles on behalf of clients, and I guess to some degree we're stuck with that decision when it doesn't seem like it's a very good idea with respect to Supreme Court advocacy. Yeah, I'm going to do it.
I'd like to address that question from sort of a different angle, but also to very briefly, because it is relevant to the obligation to your clients, to just explain what happened in Wewe versus Kiobel. So both Wewe and Kiobel involved very similar, and in some cases the same set of human rights abuses in Nigeria and the same defendant. What happened in Kiobel was kind of a bizarre litigation story, because the cases were mostly litigated together, but there was one point at which the Kiobel defendants, or the Kiobel plaintiffs, got an adverse ruling from the district court on, of all things, the actionability of extrajudicial killing or summary execution as a violation of international law, which nobody saw coming, and it was primarily because it had not been briefed particularly well, because everybody assumed that this was well established. And so the Kiobel plaintiffs at that point took an interlocutory appeal. And when this issue came up in the Wewe case, we had more notice that it was going to be an issue, and the judge actually changed her mind and said we could proceed on our summary execution claims for the same executions. It was literally the same trial and hangings at issue. But the Kiobel plaintiffs at that point were already on an interlocutory appeal. And then more bizarre things happened, which is that the Second Circuit changed the question from the actionability of summary execution to corporate liability, and came up with a crazy answer, courtesy of Judge Cabranes. And then that was then appealed to the Supreme Court on the theory that, look, immunity for corporations for genocide and crimes against humanity may be a bridge too far, even for the Supreme Court. And then
in the same year as Citizens United, yeah.
Yeah,
big
so
shock.
that was, well, but it may well have been, which is why the Supreme Court then changed the question. So you had 2 stages at which something unexpected happened in an appellate court in a way that was, I think, almost completely unpredictable to the litigants. But to answer your question in terms of what we can do, I think it goes beyond case selection and briefing, because what's at base in some of these Supreme Court decisions partly in Kiobel, but even more so if you read the Daimler-Chrysler v. Baumann decision, is a Supreme Court that is seeing itself almost in the same way the Lochner Court did as the steward of the global economy and the United States' place therein. And they're very concerned that this kind of litigation might screw things up for the United States and the U.S. as a place for foreign investment, as well as U.S. corporations abroad in the economy. And what's really needed here is not just on the litigation side, but also on the advocacy side, to demonstrate to the court that it is really Congress that should be in the position of making economic decisions, and that ultimately Congress needs to send some messages that in fact accountability for serious human rights abuses does not actually cause the economy to grind to a halt, and in fact is a good thing for U.S. businesses, most of whom are actually good actors.
I have one more very substantive question that I want to ask, but I just want to respond to that formulation, the kind of court as Lochner formulation, and just by saying what I think rather obviously the other side would say about this. They would say to the contrary that when the United States is, as it is in the post-Cold War period, before 2008, the financial crisis, the decline of the U.S. economy, and the rise of China, before that period, the United States is in this glorious moment where it is not only the world's sole dominant superpower, but also has, through the information revolution, become one of the most creatively growing global economies. And under these idealistic circumstances, the court might say, interpreting unclear congressional statutes is something that can be done a little bit aggressively. The United States could be in the position of, assuming that Congress's intention is unclear, which is certainly the case for the ATS, which after all goes back more than 200 years, the court may think it's capable of being aggressive, both geopolitically and economically, and not really worrying about the costs. But that after 2008, with the American global position declining both geostrategically and economically, it might be inclined to be skeptical about going further than Congress clearly intended. So from the other side's perspective, I think they would strongly reject the idea that it's Lochnerizing to refuse to extend an 18th century statute to cover contemporary human rights violations. And may I just say that I think they would be correct about that. I think it's incorrect to call it, I don't agree that it would be Lochnerizing. It might be morally the right thing to do, but I don't think it's Lochnerizing to decline to do it. I mean, you guys, I think, are in the position of being activists, which is a good thing to be. But to say that the other side are activists for refusing to be activists seems to me to be it seems to be more a litigator's formulation than let's say, an objective formulation.
I guess the way I would respond to that is to say that, and I'm glad we're getting actual debates, is to say that Congress doesn't have a problem stepping up to protect powerful moneyed interests when the court goes too far, as it rarely does, in challenging them and in standing up for victims. So that, from a jurisprudential perspective, the court should be erring on the side of liability and accountability for corporations, and trusting that, if they ever go too far, that Congress will be quite comfortable in stepping in to set those limits.
I think that's a great argument, but it's a different argument. So the question I want to ask is, we only have a few minutes left, is what is your perfect next case? I mean, I understand you can't control it, but, is it Shamari, where it's U.S. citizens acting for a U.S. corporation operating abroad, killing Iraqis? Is it, what's your best case where you think you could make out sufficient contact with the United States to satisfy Justice Kennedy?
So I think one of the questions is, first, is it a corporate case at all? So El-Shamari versus Kaki. It may be that the next case you want to go up is actually not a corporate case, to just solidify a principle of either let's actually affirm Filartiga directly, so you get Kennedy on that. So that may be the best case going up. But in the corporate context, I think you want something.
And how would you so can you fill in, how would you satisfy the question of jurisdictional connection to the United States in a non-corporate case. That would be good to hear also, because obviously the great fear is that Kiobel makes Filartiga not
Yes.
affirmable because it's, to people from another country for conduct that takes place in another country.
Right, so I think that gets to the question about how would you say an individual who's here, you have to have jurisdiction over them. And that may be a different equation than in the corporate context, given what's going on with Daimler Chrysler versus Baumann. So the question is, does the individual jurisdictional equation change? So does the person be here? Are they essentially a safe harbor?
But I mean, as you said, the extraterritoriality argument in Kiobel is written without reference to corporateness at all.
Yes.
So, I mean, the court's going to begin, Justice Kennedy is going to begin by saying we apply the framework of Kiobel. So what I'm wondering is, what's your picture of the best facts to get the court to say, okay, on these facts, we overcome the presumption against extraterritoriality and revivify the field of discourse?
One of the main arguments may be that Filartiga is all about the safe harbor and concerns of harboring individuals, and that's what touches and concerns the United States. That's an argument that is there. The other argument, I think, is the one goes back to Paul talking about it, which is the U.S. nationals, and that being touching concern the United States. And so I think either
as victims or as perpetrators
as
or
perpetrators.
Both? Perpetrators.
It can't as perpetrators. I think those are the two scenarios that go up and are taken seriously by Kennedy initially. Divorced from conduct questions. Conduct is clearly an equation here as well. So if you have a U.S. national with some conduct in the United States, like aiding and abetting torture that's taking place abroad, that would supplement the facts as well, because there would be conduct in the United States. So some mix of things with U.S. nationality and conduct in the United States, even if it isn't the torture taking place in the United States, but assisting torture abroad from the United States as a launching point, essentially. Those would be facts, I think, that Kennedy and others would look at in a different vein than Kiobel, where everything's taking place outside the United States.
Well, if there's one thing that emerges from this conversation is there's a lot more to be said, and that's a good thing because there's a lot more time in which for it to be explored and said. So I'd like to thank all of the panelists and thank Paul remotely, and I think we should give them a round of applause.